For example, after March 27, 2017, Zombie's advertising revenue fell from $300 to $500 per day to $20 to $40 per day. The court added that while the guaranteed payments did not appear to be large, unless the consideration given was so one-sided as to create an issue of unconscionability, the courts are not in a position to decide whether legal consideration agreed to by the parties is or is not fair. Hello everyone, I'm Leonard French, your favorite copyright attorney, and I get to be the bearer of bad news today. Unfortunately, the ZombieGoBoom class action Adpocalypse lawsuit against Google and YouTube has been dismissed in its entirety with prejudice. The thing is completely over. With that said, I thought we should explore the story a little bit and go over the judge's opinion and reasoning as to why ZombieGoBoom's claims don't reach a level of legal remedy that a judge can do anything about. Now, you might remember that ZombieGoBoom filed a class action complaint about a year ago. Google filed a motion to dismiss at the end of November 2017, mostly claiming that the terms of service disclaim any obligation of Google to display ads. ZombieGoBoom filed an opposition against the motion to dismiss, claiming that the sudden, unilateral, and arbitrary changes in the monetization policy amounted to various kinds of breach of contract, including even implied covenant of good faith and fair dealing, quasi-contract, interference with plaintiff's economic advantage, and harm to healthy competition. They argued that the partner terms do not bar the case and that the judge can find for these things even when the YouTube terms of service say otherwise. The judge, unfortunately, did not agree. In his order granting defendant's motion to dismiss, he writes, "Plaintiffs are James Sweet, Chuck Meir, and ZombieGoBoom, the owners of a YouTube channel that has been able to monetize the content it displays on YouTube because Google and YouTube have a program under which content providers can get a cut of the revenue that YouTube makes from third-party advertisements. ZombieGoBoom has filed a class action lawsuit against YouTube, asserting that its revenues and the revenues of other content providers have significantly fallen after YouTube put restrictions on the placement of advertisements that did not meet YouTube guidelines. Currently pending before the court is YouTube's motion to dismiss. Having considered the briefs and accompanying motions, as well as the oral arguments of counsel, the court hereby grants the motion to dismiss." In its first amended complaint, Zombie alleges as follows. YouTube is a video sharing website which contracts with content providers to upload videos to be viewed by members of the public worldwide. YouTube has been able to monetize the content on its website by permitting third-party advertisers such as Walmart, Verizon, General Motors, and others to place advertisements at the beginning of videos. YouTube shares the advertising revenue it makes with content providers, which is an incentive for content providers to focus on creating content as a full-time job. Zombie is a content provider who, prior to the alleged misconduct by YouTube, was able to earn a living wage by working exclusively as a YouTube content provider. From approximately 2011, when ZombieGoBoom was founded, until the time of the alleged YouTube misconduct, Zombie made approximately $10,000 to $15,000 per month. YouTube uses a program called AdSense to control placement of advertisements depending on the content provided and the audience. In or about March of 2017, YouTube changed the algorithm used in AdSense. Apparently, YouTube took action because in early 2017, it was hit with a wave of bad press after advertisements were placed on videos that contained hate speech and sexually explicit material, which in turn led to approximately 5% of YouTube's advertisers to back out of agreements to place their advertisements on YouTube's content providers' videos. YouTube changed the AdSense algorithm without notice, advanced or otherwise, to the content providers without the consent of content providers and without sharing with content providers what exact substantive changes were made to the algorithm. In spite of the above allegation, Zombie seems to admit that YouTube did release new guidelines regarding restrictions put on the placement of advertisements. The change to the AdSense algorithm was an attempt to automatically weed out inappropriate content without the use of human oversight. As it turns out, the algorithm was not effective. It under-inclusively failed to capture and demonetize content that was sexually explicit, racist, or otherwise not in compliance with the spirit of YouTube's guidelines, and 2, it overly inclusively demonetized content that did not violate the spirit of the guidelines guidelines and was not objectionable to advertisers. Zombie fell into the latter category. Zombie claims that there are thousands of other examples, although it identifies only one other example in its complaint, referring to a review of a burger which was deemed objectionable under the new AdSense algorithm. Zombie and other content providers have dubbed the date that the algorithm was changed Adpocalypse. As a result of the algorithm change, Zombie's advertising revenue fell. For example, after March 27, 2017, Zombie's advertising revenue fell from $300 to $500 per day to $20 to $40 per day. Adpocalypse has also affected Zombie in other economic ways. For example, prior to the Adpocalypse, a third party offered Zombie $60,000 to purchase all of its existing online content. That offer, however, was rescinded after the Adpocalypse. Also, prior to Adpocalypse, Zombie was offered $25,000 to promote other products outside the context of YouTube. After Adpocalypse, Zombie was only able to contract for $3,500, and ultimately it received only $1,500 because the response to the promotion did not garner the business anticipated. Based on the above allegations, Zombie has asserted the following claims for relief: violations of the California Business and Professions Code. They allege that YouTube has engaged in unfair conduct because it has devised and executed a material change to its advertising terms and AdSense practices without providing any notice either before, during, or after in any conspicuous manner to plaintiffs or other providers, and with the intent and effect of stifling open and vigorous competition in the market for content providers. YouTube's conduct was also unfair in that it has forced plaintiffs and class members to adhere to its undisclosed practices. Tortious interference with contractual relations and/or prospective economic advantage. According to Zombie, YouTube was aware that plaintiffs and class members routinely enter into such related contracts with third parties, and that changes to the monetization structure, including demonetizing videos without notice or recourse and altering the terms by which videos would receive compensation, would have a direct impact on these contractual arrangements. 3. Breach of contract. Zombie alleges that the parties had a contract under which it was permitted to engage with YouTube as a content provider, and a contract that governed the monetization structure for the posting of its content on YouTube. Zombie further alleges that YouTube breached the contracts by altering the terms and conditions governing how plaintiffs and class members' videos would be monetized. Breach of the duty of good faith and fair dealing. According to Zombie, YouTube's conduct has unfairly prevented Zombie from receiving the benefits of the above contracts. Zombie alleges that YouTube created a contract or quasi-contract through which it received and continues to receive the benefit of monetary compensation without providing the consideration promised to plaintiff and class members. YouTube now challenges Zombie's complaint in a 12b6 motion to dismiss. Although YouTube's motion is a 12b6 motion, it has filed a declaration in support of the motion and attached to the declaration several pieces of evidence. The declaration is from a software engineer at YouTube who testifies as follows. Through the YouTube website, users can upload, share, and watch videos for free. To upload videos, a user must first create an account. During the process of creating an account, a user must assent to the terms of service. The terms of service incorporates the YouTube community guidelines, which prohibit and caution users from uploading several categories of inappropriate video content. A content provider has the option of participating in a program that allows users to monetize their videos by allowing Google to display third-party advertisements in or alongside those videos. To participate in this program, users must manifest their assent to additional terms and conditions. For most users, these are the standard YouTube Partner Program terms. The YouTube Partner Program terms expressly incorporate the TOS and YouTube Partner Program policies. With respect to Zombie, it assented to the TOS on March 29, 2011 when it first created its YouTube account and channel. In addition, it assented to the YouTube Partner Program terms that were operative during the time of the events alleged in the complaint, March 2017, on January 3, 2017. Attached to the declaration are the TOS, the community guidelines, the partner program terms, and the partner program policies. YouTube argues that the court may consider this evidence even on a 12b6 because Zombie expressly referred to them in its complaint. The court agrees that it may take into consideration the exhibits attached to the declaration, in particular because the terms are referenced and relied upon in Zombie's complaint, and the community guidelines and partner program policies are incorporated by reference. Zombie does not dispute that the documents may be taken into consideration. In fact, Zombie asks the court to consider the documents itself. For the purposes of the pending motion, the critical contract term is one contained in the partner program terms. That provision states as follows: YouTube is not obligated to display any advertisements alongside your videos and may determine the type and format of ads available on the YouTube service. To survive a 12b6 motion to dismiss for failure to state a claim after the Supreme Court's decisions in Ashcroft v. Iqbal and Bell Atlantic v. Twombly, a plaintiff's factual allegations in the complaint must suggest that the claim has at least a plausible chance of success. In other words, the complaint must allege factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The Ninth Circuit has settled on a two-step process for evaluating pleadings. First, to be entitled to the presumption of truth, allegations in a complaint or counterclaim may not simply recite the elements of a cause of action, but must contain sufficient allegations of underlying facts to give fair notice and to enable the opposing party to defend itself effectively. Second, the factual allegations that are taken as true must plausibly suggest an entitlement to relief such that it is not unfair to require the opposing party to be subject to the expense of discovery and litigation. Notably, the plausibility standard is not akin to a probability requirement, but it asks for more than a sheer possibility that a defendant has acted unlawfully. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. In its motion to dismiss, YouTube makes a number of arguments, but the primary one is that all of Zombie's claims for relief lack merit because the conduct of which Zombie complains, in essence, failure on the part of YouTube to post advertisements along Zombie's content, is expressly permitted by the party's contract. While the above provision places no limit on YouTube's decision-making with regard to advertisements, Zombie nonetheless argues that the disclaimer, YouTube is not obligated to display any advertisements, has implied limits, and it must be applied in good faith or otherwise the term is unconscionable and/or the contract illusory. Zombie's unconscionability argument lacks merit. Zombie admits that unconscionability requires both procedural and substantive unconscionability, although there is a sliding scale, meaning that the more substantively oppressive a contract term, the less evidence of procedural unconscionability is required to come to the conclusion that the term is unenforceable and vice versa. With respect to procedural unconscionability, Zombie contends that this element is satisfied because the contract between it and YouTube is one of adhesion. Whether the challenged provision is within a contract of adhesion pertains to the oppression aspect of procedural unconscionability as opposed to the surprise aspect. A contract of adhesion is imposed and drafted by the party of superior bargaining strength and relegates to the subscribing party only the opportunity to adhere to the contract or reject it. Absent unusual circumstances, use of a contract of adhesion establishes a minimal degree of procedural unconscionability, notwithstanding the availability of market alternatives. Arguably, the label of adhesion contract is not entirely fair in the instant case. The instant case is not a consumer or employment case where adhesive contracts are typically found. Even if the contracts at issue were deemed adhesive, that simply establishes a minimal degree of procedural unconscionability such that Zombie would have to establish a fair amount of substantive unconscionability in order to prevail. In another case, where plaintiff sued regarding the removal and relocation of its music video on YouTube, the court found the level of procedural unconscionability to be slight, as plaintiff does not lack meaningful choice, even though YouTube is undoubtedly a popular video sharing website. Plaintiff could have publicized the music video by putting it on various other file sharing websites or on an independent website. Zombie argues there is substantive unconscionability because cases have held that a term that allows a party to unilaterally modify a contract is unenforceable. But this case law is not on point because Zombie has pointed to no term within YouTube's TOS or partner program terms that gives YouTube such unilateral right to modify the contract. The term at issue in the instant case, YouTube is not obligated to display any advertisements alongside your videos, has been in the contract from its inception and is not a unilateral modification provision. Absent a viable theory of unconscionability, Zombie's argument against dismissal comes down to its contention that there must be limits on the above provision. YouTube is not obligated to display any advertisements alongside your videos, based on the implied covenant of good faith and fair dealing. According to Zombie, Similarly, absent application of such covenant, the contract is illusory and unenforceable. While the implied covenant of good faith and fair dealing may be applied where contract terms are silent, its application to contradict an express term of a contract is narrowly circumscribed. In this regard, Third Story Music v. Waits is instructive, a 1995 case. The plaintiff in Third Story was a company that owned the rights to the musical output of singer-songwriter Tom Waits from 1972 to 1983. The plaintiff entered into an agreement with the defendant under which 1. The plaintiff was to produce master recordings featuring performances of Mr. Waits, and 2. The defendant had the right to manufacture, sell, distribute, and license the recordings, but the defendant may, at its election, refrain from any or all of the foregoing. As a consideration, the plaintiff was to receive as a royalty a percentage of the amount earned by the defendant from its exploitation of Mr. Waits' music. In addition, the defendant was required to pay a specific dollar amount as an advance on royalties. The plaintiff and defendant's dispute arose when the plaintiff wanted to license some of Mr. Waits' recordings, but the defendant refused because Mr. Waits did not personally approve the licensing request. The plaintiff sued for breach of the implied covenant of good faith and fair dealing. In response, the defendant countered that the clause in the agreement permitting it to, at its election, refrain from doing anything to profitably exploit the music is controlling and precludes application of any implied covenant. The plaintiff in turn argued that where a contract gives a party discretionary power, that power must be exercised in good faith. The court posed the issue that is particularly apt here. When an agreement expressly gives one party absolute discretion over whether or not to perform, when should the implied covenant of good faith and fair dealing be applied to limit its discretion? In answering that question, the court looked first to a Supreme Court of California case, Karma Developers v. Marathon Development of California. There, the parties entered into a lease agreement which provided that if the tenant found a potential sublessee and asked the landlord for consent to sublease, the landlord had the right to terminate the lease, enter into negotiations with the prospective sublessee, and appropriate for itself all profits. The Karma Court noted that the implied covenant of good faith and fair dealing had particular application in situations where one party is invested with discretionary power affecting the rights of the other. Such discretionary power must be exercised in good faith. However, the Karma Court ultimately upheld the right of the landlord to terminate the lease in order to claim for itself all profit from the expected sublease. The landlord's right arose from an express term in the parties' agreement, and in general, an implied term should not be read to vary an express term. The Third Story Court recognized the tension in Karma and stated that it would try to reconcile the apparent inconsistency between the principle that the covenant of good faith should be applied to restrict exercise of a discretionary power, and the principle that an implied covenant must never vary the express terms of the parties' agreement. The court noted first that it must take into account a long-established rule concerning implied covenants. To be imposed, 1. The implication must arise from the language used, or it must be indispensable to effectuate the intention of the parties. 2. It must appear from the language used that it was so clearly within the contemplation of the parties that they deemed it unnecessary to express it. 3. Implied covenants can only be justified on the grounds of legal necessity. 4. A promise can be implied only where it can be rightfully assumed that it would have been made if attention had been called to it. And 5. There can be no implied covenant where the subject is completely covered by the contract. The Third Story Court went on to discuss several cases cited in Karma for the proposition that a discretionary power must be exercised in good faith. For example, in Purdue versus Crocker National Bank, a bank was given discretion to set non-sufficient funds charges to be paid by the customer. The contention was that since the charges were subject to the bank's sole discretion, the contract lacked mutuality and was therefore illusory. By its ruling that, under California law, an open term in a contract must be filled in by the party having discretion within the standard of good faith and fair dealing, the court in Purdue was able to impose an objective standard and save an otherwise illusory agreement. The Third Story Court went on to explain that in Purdue and other similar cases, the courts were forced to resolve contradictory expressions of intent from the parties. The intent to give one party total discretion over its performance and the intent to have a mutually binding agreement. In that situation, imposing the duty of good faith creates a binding contract where, despite the clear intent of the parties, one would not otherwise exist. Faced with that choice, courts prefer to imply a covenant at odds with the express language of the contract rather than literally enforce a discretionary language clause and therefore render the agreement unenforceable. In short, the implied covenant was applied to contradict an express contractual grant of discretion when necessary to protect an agreement which would otherwise be rendered illusory and unenforceable. In other words, in order to effectuate the party's intent to enter into a binding contract. But the third story court asked, does a different result ensue where the contract is unambiguous, otherwise supported by adequate consideration, and the implied covenant is not needed to effectuate the party's expressed desire for a binding agreement? We believe it does. The third story court looked at cases cited in Karma where the implied covenant was not applied to limit an express contractual provision giving complete discretion to one party. For example, in Brandt versus Lockheed Missiles and Space Company, the employment contract at issue provided that when an employee's invention was deemed of sufficient value to apply for a patent, and the patent application was granted, the employee would, in all cases, receive a total of $600. In addition, the agreement said the employer may, but is not obligated to grant any employee an additional special invention award. In response to two employees' claims that failure to make an adequate special invention award in their case violated the covenant of good faith, the court held, few principles of our law are better settled than that the language of contract is to govern its interpretation, if the language is clear and explicit. Here, the language of the parties' contract of employment, the patent plan, could not be more clear and explicit. It says that Lockheed's Invention Awards Committee may, but is not obligated to, grant the Special Invention Award, and that its decision on such matters shall be final and conclusive. Lockheed had fully respected the patent plan's language, and it may not reasonably be said that in doing so it violated a duty of good faith and fair dealing. The third story court emphasized that in Brandt and the other like cases, one of the parties was expressly given a discretionary power, but regardless of how such power was exercised, the agreement would have been supported by adequate consideration. There was no tension between the parties' express agreement and their intention to be bound, and no necessity to impose an implied covenant to create mutuality. The conclusion to be drawn is that the courts are not at liberty to imply a covenant directly at odds with a contract's express grant of discretionary power, except in those relatively rare instances when reading the provision literally would, contrary to the party's clear intention, result in an unenforceable, illusory agreement. In all other situations where the contract is unambiguous, the express language is to govern, and no obligation can be implied, which would result in the obliteration of a right expressly given under a written contract. Ultimately, the third story court found that the case before it was more like Brandt than Purdue. The illusory promise that the defendant could at its election refrain from all marketing efforts was not the only consideration given by the defendant. Under paragraph 33 and 34 of their agreement, the defendant promised to pay the plaintiff a guaranteed minimum amount no matter what efforts were undertaken. It follows that whether or not an implied covenant is read into the agreement would be supported by consideration and would be binding. The court added that while the guaranteed payments did not appear to be large, unless the consideration given was so one-sided as to create an issue of unconscionability, the courts are not in a position to decide whether legal consideration agreed to by the parties is or is not fair. The question for the court is whether the instant case is more like Purdue, where the implied covenant was found to apply and thus restricted defendant's discretion, or Brandt and third story, where the implied covenant was found not to contravene an express provision conferring complete discretion on the defendant. The court finds the latter applies. Regardless of how YouTube exercised its discretionary power in determining whether to display advertisements under the partner program terms, the agreement, which consists of both the TOS and partner program terms between Zombie and YouTube, was supported by adequate independent consideration. In particular, YouTube allowed Zombie to post videos on its forum free of charge in exchange for getting a license to its content. The ability to post videos, even without advertising revenues, can be valuable to content providers in reaching a wide audience. Moreover, the YouTube partner program encompassed more than just advertising revenues. Content can be monetized in other ways such as subscription revenues. I thought subscription revenues were discontinued as of like January 2018. So somebody correct me if I'm wrong there, but I think the judge is wrong there. We don't have paid subscription revenues on YouTube or paid content on YouTube anymore. Accordingly, the provision of the YouTube Partner Program terms conferring upon YouTube complete control over decisions regarding advertisements need not be deemed subject to the implied covenant of good faith and fair dealing in order to prevent the agreement from being illusory. To the extent Zombie suggests that YouTube does not in fact have complete discretion under the YouTube Partner Program terms, that argument has no merit. According to Zombie, the Partner Program policies note that failing to comply with these policies could result in disabling ads from your content, making the default assumption that ads are not disabled from content. Further, the monetization basics and policies pages incorporated into the Partner Program policies outline how ads will be served onto videos that are approved for the Partner Program, and goes as far to note that once you turn on monetization, it may take some time for ads to appear, not that ads may not appear at all. This provision does not negate the sweeping force of the clear and explicit provision that YouTube is not obligated to display any advertisements alongside your videos. Nothing in the Partner Program policies suggests that violation of the policies is the only reason why YouTube is not obligated to display advertisements. It is simply one reason. Accordingly, the court agrees with YouTube that all of Zombie's claims are subject to dismissal given the explicit terms of the agreement. Moreover, the dismissal is with prejudice. YouTube challenged Zombie's original complaint on the same ground, which led Zombie to file an amended complaint. Because Zombie's amended complaint failed to cure the deficiency, and because the terms of the agreement are clear, any further amendment to the complaint would be futile. For the foregoing reasons, YouTube's motion to dismiss is granted with prejudice. Accordingly, the clerk of court shall enter judgment in accordance with this opinion and close the file in this case. It is so ordered. Edward M. Chen, United States District Judge. So, to recap, just in case any of that heavy contract language was at all unclear, the judge is saying that the terms and conditions of YouTube's contracts, all 3 or 4 of them, are clear and unambiguous, and therefore this doesn't become a case where we need to implicate the covenant of good faith and fair dealing. That covenant or that condition, saying that the party with all of the decision-making ability, the discretion, that party has to be fair in their use of that discretion, that only applies if the contract would be unenforceable without some help. This contract in ZombieGoBoom's case is not that kind of contract. The contract is unambiguous, it has clear terms, the parties were on notice, and therefore the judge is saying that we can't undo those terms of the contract just because a party doesn't like the way they're being enforced, the way that discretion is being enforced, that YouTube is allowed to make those decisions, and that you're on notice and have agreed to those terms as part of your YouTube account, and if you have a problem with that, your only real remedy is to take your video someplace else and do your business in a different way. So we've seen many companies doing that. Even yours truly has diversified to Patreon and other sources of sponsorship. We're looking into other sorts of things after pretty much every one of our videos gets demonetized. The only positive news I can offer is that it does appear that some of the remonetization process is becoming faster, although this has only happened after all of the smaller channels got demonetized against their will permanently, thanks to YouTube's new cutoff for the threshold for monetization. So it's a really weird world that we live in. ZombieGoBoom apparently went from a 6-digit income to a 5-digit income, and that's pretty dramatic. I think they said they were supporting 4 families, and several of them had to move back in with parents or other family members or something like that. So it was pretty bad, and it even affected our channel. Like I said, we've diversified to Twitch and other ways, so that we can weather the storm, and that if YouTube makes further unilateral changes that apparently they're allowed to do, that we will be prepared for it. So what can you do from here? Well, Don't rely on YouTube to be 100% clear on everything, because they don't have to be. They only have to say what they've said in the terms of service there, and look, a judge agrees with it. You're not going to be able to take them to court on these exact same facts and win. If you have a problem with YouTube's terms of service and the way they're demonetizing things, support Floatplane, support Twitch, or support other platforms that are going to grow and try to fill this gap that is left by this new system. So definitely let me know what you think of that in the comments below. You can also reach out to us on Twitter or on our Discord. We have a website at Lawful Masses where you can read articles or find documents, and we have rewards for our followers at certain tiers, not the least of which are our 10 $50 plus supporters for the month of March. Thank you very much to DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrak, John H. Anderson, Vera Mentane, and Sean McNamara. Your support is very much appreciated. We also have over 200 $5 plus supporters that are scrolling on the screen right now as I speak. You are absolutely amazing. You're donating over $1,000 a month collectively, and I'm exploring some new ideas for rewards for all of the patrons. One of the things that was suggested today was sort of a monthly lottery to choose a story or two or so for the next week or next month's production, and everybody could get a vote either based on their donation or based on their tier or something. We're talking about it. We don't make changes quickly around here because we don't want to upset anyone. So I'm happy to hear your feedback on any of that. Thank you for watching. I look forward to seeing you in my next video and on the Sunday live show at 10 a.m. on Twitch, 10 a.m. Eastern on Twitch. I'm Leonard French, your favorite copyright attorney. Have a great weekend.